Ladies and gentlemen, welcome back to the IndieZone. My name is Kathy. I am providing this presentation as a follow-up to my presentation of yesterday, which was the 12th of January, 2025. Today is the 13th, regarding the matter of would potentially Mr. Kohberger be required to take the stand regarding his alibi defense. And I have received so much feedback from that presentation because, first and foremost, I've had at least a couple of people say, don't you know that Mr. Kohberger cannot be compelled to testify against himself? When I said very clearly in that presentation, and I do it over and over again, number one, Mr. Kohberger is cloaked with the presumption of innocence and will be until or unless one of two things happen. And that is that he either pleads guilty to the 5 crimes that he is charged with, or he is adjudicated guilty. And moreover, under the 5th Amendment to the United States Constitution, he cannot be compelled to ever give testimony against himself, nor is he required to put up a defense of any kind. But the issue was that he has already articulated an intention to raise an alibi defense, and there is statutory language, whether we like it or not, that governs what he was supposed to have done within 10 days of the State of Idaho's demand back in 2023, but has not. And moreover, the supplementation that was filed in 2024 addresses the fact that he intends to call Cy Ray, a CSLI proposed expert, to testify to give some partial corroboration of where he was the early morning hours of the 13th of November, 2022. And what, ladies and gentlemen, I posed yesterday, what happens if Judge Stephen Hippler, who is the gatekeeper for all proposed expert witnesses, and we must call them not expert witnesses, but proposed from both the state's side, whoever they disclosed on the 18th of December, 2024, which we don't know, it's under seal. We have a little bit of information regarding a filing that the state submitted that tells us who some of the people that they're calling as experts supposedly are. But none of them are experts until Judge Stephen Hippler says they are. Same with the defense. And so because Mr. Ray was raised as a partial corroborator regarding the alibi defense that Mr. Kohberger has told the state he intends to raise trial, well, what if Judge Hippler strikes him as an expert witness? Not only does that mean that Mr. Kohberger will not be able to use him and to use his technology to determine where he was allegedly on the morning of November 13th, 2022, but there's an additional problem because he's named as a partial corroborator in the alibi supplementation defense that Mr. Kohberger filed. I have received also communication from Bob Mata of Defense Diaries regarding that presentation. And again, if you haven't listened to it, please do. It's called Will Mr. Kohberger Be Required to Take the Stand regarding alibi defense, where he says it's more of a Fifth Amendment issue, which I already addressed, I thought, in the presentation itself. But nonetheless, it's more of a Fifth Amendment issue. If he does not plan on testifying, then the obstacle for the defense becomes, how do you get the alibi evidence in? Phone data is the obvious answer, which can be introduced without Kohberger having to take the stand. I wrote back and asked, how does this get him around the statute, which clearly requires witnesses' names and addresses to testify in support of the alibi defense? Thanks. So Mr. Mata may be busy, although I did send this about 8 hours ago. I haven't heard back. I'm hoping that I will hear back from him at one point. But there's a couple of issues here with the statutory language that I really didn't even go over yesterday that hit me in the face today. First and foremost, going to what Mr. Mata had stated here, the statute is very clear. You can't have documents take the place of people, at least the way the statute's written that I'm reading. And if there's an Idaho attorney out there that could tell me differently, I would greatly appreciate this. I'm just giving this as an opinion. I don't profess to be an attorney in Idaho. I do not profess to have any additional expertise. I'm just reading the statute. And what it says is 1519 Idaho statutes, notice of defense of alibi. 1. At any time after arraignment before a magistrate upon a complaint and upon written demand of the prosecuting attorney, the defendant shall serve within 10 days or at such different time as the court may direct upon the prosecuting attorney a written notice of his intention to offer a defense of alibi. Such notice by the defendant shall state the specific place or places at which the defendant claims to have been at the time of the alleged offense, and the names and addresses of the witnesses upon whom he intends to rely to establish such alibi. Now, please take note, the word shall here in this statute twice, that's mandatory. That's not you could, you might, you should. It is mandatory language. You will do these things. And it says witnesses. I don't know how documentation could ever take the place of a witness, such as a classic case, a person's at work, crimes occur on a certain day and time when he is at work, and his supervisor or her supervisor is named as an alibi witness who will be able to testify at trial that the person was indeed at work and therefore nowhere in the area of where the crimes happened. That is a classic alibi defense. There's another issue, is that usually alibi witnesses have no stake in the action. They're not there on behalf of the state or the defendant. Mr. Ray has already testified on behalf of the defendant. So he's not like the employer who gets this notification that, hey, we're going to use you as an alibi witness, and says, oh, no, I don't want to have to go to court and testify. But he has to. He's compelled to, or she's compelled to. So that raises another issue. How is Judge Hippler, if it comes down to Mr. Kohberger continuing to want to use Mr. Ray as an alibi witness, how is that going to appear if Mr. Ray is not a disinterested person? He's not an employer. He's not a person who sat on a plane with someone while they're flying out of the country and can testify that the person was on a plane flying over to Europe at the time the crimes happened. Mr. Ray has what's called a stake in the action. But there's even another issue that may make the fact that Mr. Kohberger might not be able to raise this alibi defense at all, no matter what. And it's going back to the statutory language, which states that you have to respond within 10 days of the date that the prosecutor demands. Now, Mr. Thompson, on behalf of the state of Idaho, filed that notice of alibi demand on May 23rd, 2023, which means that the alibi defense information was due the beginning of June 2023, according to the statute. Shall respond within 10 days. Not might, not could, not should, and only the judge has the authority to extend that deadline. Well, we see on page 2 that, quote, the parties subsequently stipulated to extend the statutory time for the defendant to provide notice of alibi and comply with Idaho Code 19519 to July 24th, 2023. I see no order signed by Judge John Judge who authorized that enlargement of time. And the statutory language says parties can't stipulate to it. No, what it says is that upon written demand of the prosecuting attorney, the defendant shall serve within 10 days or at such different time as the court may direct. I don't see any written order anywhere on the docket that the court authorized an extension of time. So that may be grounds for Judge Hippler to say you blew the statute, you didn't have authority, state and defense, to extend the time. You really needed to have Judge John Judge who's no longer presiding over the case because the case has been transferred, to enter an order saying that you had until such and such a date to respond to the alibi demand. The issue is still pending because this motion to compel has never been entertained. And one of the issues that the state was saying is, look, either bar him from being able to present this alibi evidence and raise this alibi defense, or at the very last page, it says the only person who can really testify, according to what we have right now, is Mr. Kohberger himself, which means he would need to take the stand. One final issue that I've received a lot of feedback on is that some people feel that the judge in Colorado didn't know what he was talking about, was very, very terse, was, improper in striking Cy. No, he was not, because a judge's role is a gatekeeper as to any expert witness. Judge Stephen J. Hippler will say who is qualified and who is not qualified of all of the witnesses, state and defense. And the people of the state of Colorado versus Christopher Russell Jones was an example of what happens. This is an order granting motion to exclude historical cell site location information based on TRAX, T-R-A-X software. This was rendered September 20th, 2022 at 4:52 p.m. in Larimer County, state of Colorado. And it says here that the defendant moved to exclude, under Colorado Rule of Evidence 702, evidence of historical cellular database analysis based on the use of TRAX, T-R-A-X software, on the grounds that it is unreliable. The people opposed the motion and disclosed several expert witnesses who will testify at trial. Among them is an expert who plans to discuss Jones' location based on TRAX. This is Mr. Ray. In the next paragraph, on August 26, 2022, the court held, it's called a Shrek hearing in Colorado. It's their version of the hearing that has to happen to determine if someone is qualified to serve as an expert under the Colorado Rule of Evidence 702 that's referenced in the first paragraph. And the court held this hearing and took the matter under advisement. For the reasons set forth below, the motion is granted. That means that this testimony is going to be kept out of the case and could not be presented to the jury. And the people won't be allowed to offer any testimony about Jones's location that stems from TRAX, and that was being offered by Cy. So you can go in. I provided a link to this ruling in the description to this presentation. But the bottom line is, just like this judge in Colorado, looking at Colorado rules of evidence, found that a certain witness or witnesses could not testify, were not competent because of this is unreliability. Judge Hippler will be doing that as well. So it then goes to the issue that if Mr. Ray is struck as an expert witness, he's not a lay witness who would come in and say, hey, I'm sitting in the car and I can tell you where Kohberger was every minute of the day. He's doing it through this TRAX software or some type of technology that is close to it, I would imagine. What does that do to the Kohberger alibi defense? And what about the issue that they extended the deadline without a court order? Let me know what you think. I appreciate your feedback. I hope that this helps to clarify a lot of the questions and comments that I have received. This will now conclude this episode of the IndieZone. Thank you, as always, for joining us here today.